Hello, my friend. Whether you have clicked on our videos for the first time or you are a companion of our Academy's journey, you are interested in international law, and that's wonderful. My name is Walter, and I have the honor to represent IntlLaw Academy lectures about sources of international law. We have covered studying the first two primary sources of international law. If you want, you can find the videos about those in the playlist mentioned above. And now we are moving on to the last primary source of international law, general principles of law. So if you are eager to join us, let's begin. My friends, having walked together through treaties and custom, we come now to the third pillar found in Article 38 of the Statute of the International Court of Justice, the general principles of law recognized by civilized nations. These principles are quieter than treaties, less visible than customs, but no less essential. They are the fail-safes of the international legal system, the rules we turn to when the written instruments and the habits of states leave a gap. So, what do we mean by general principles of law? At bottom, these are fundamental rules of legal reasoning and justice that recur across the world's municipal legal systems. Think of them as the common grammar of law. Concepts like good faith, the binding force of agreements, pacta sunt servanda, estoppel, res judicata, due process, and the prohibition of retroactive penal legislation. They are not invented ad hoc by international judges. Rather, they are distilled from the patterns of legal institutions and doctrines that most national systems share. There is a useful way to understand the source of these principles. Where custom draws on repeated state practice plus legal belief, and treaty is the express will of states on paper, general principles are drawn from comparative law, the common rules, methods, and logical structures found in domestic courts, legislation, and legal doctrine. International tribunals, when stymied by the absence of treaty text or clear custom, look downwards into municipal law and ask, what rule or principle is so widely accepted and so fundamental that it can be relied upon as international law? General principles perform several essential functions. First, gap filling. They prevent a vacuum. When international law is silent on a particular issue, general principles provide a lawful basis for a decision. Second, interpretation. They guide how treaties and customs should be understood and applied, often supplying background norms that make the text sensible. Third, legitimacy and fairness. These principles root international decisions in widely recognized notions of justice, preventing arbitrary outcomes. Finally, they can limit or moderate the application of other sources, for example, insisting that treaty obligations be performed in good faith. Another vital role of general principles is their function in preventing a non-liquet, a situation where a court or tribunal might claim the law is silent and we cannot decide. In international law, such silence would threaten the authority of the legal system itself. General principles step in to fill the gap, ensuring that justice is not denied. They provide a safety net, guaranteeing that the International Court of Justice and other tribunals can always deliver a decision, even when treaties and customary law are unclear or incomplete. Scholars have long debated the exact character of general principles. Some are cautious and positivist. They argue that a principle qualifies only if it is demonstrably common to a substantial number of domestic systems. For them, comparative evidence, court decisions, statutes, legal doctrine is the key. Others adopt a more normative or natural law posture. They see general principles as reflecting deeper moral or rational foundations of law, what some traditions call the conscience. From that view, the principles are not merely descriptive of municipal systems, but express a shared legal morality upon which international order depends. This theoretical divergence matters in practice. A narrow, evidence-based approach guards against importing one legal tradition's rules into the international plane. A broader, conscience-based approach allows tribunals greater flexibility to appeal to universal ideas of justice. Most modern international lawyers and most courts adopt a pragmatic middle course. They require some demonstrable municipal resonance for a principle, but are not blind to moral legitimacy where comparative evidence supports a rule's universality. Let me give you concrete examples to make this less abstract. The principle of pacta sunt servanda, that agreements must be kept, underpins the whole law of treaties and qualifies as a general principle, because the binding force of contracts is recognized in virtually all domestic systems. Good faith operates as a general principle in the interpretation and performance of obligations. Estoppel prevents a party from insisting on a right if it previously acted in a way that led another to rely to its detriment. You will find estoppel-like doctrines in many national laws. Res judicata, the finality of judgments, is another classic. International tribunals will not lightly reopen matters already conclusively decided. Even procedural principles, such as the right to be heard, have been imported from municipal practice because they secure fundamental fairness. In short, general principles are the stitching that holds the fabric of international law together when the larger, more visible threads are absent or frayed. They are a pragmatic instrument, comparative, principled, and cautious, and they play an indispensable role in keeping the international legal system coherent, fair, and operable. Now that we have defined and introduced the general principles of law, let us turn to their different kinds and levels of operation. To understand this, we must look at how principles function within domestic systems, within regional groupings, and in the international legal order as a whole. At the domestic level, every legal system has its own set of fundamental principles. For example, principles such as the presumption of innocence in criminal law, the requirement of good faith in contracts, or the prohibition of unjust enrichment. These are foundational rules that guide courts and legislators within a particular national framework. While they may vary in form or detail, they are recognized as essential within that legal system. The next level is the regional sphere. Here, principles may be shared across a group of states bound by geography, culture, or regional legal integration. For instance, the principle of solidarity and subsidiarity in the European Union, or the principle of non-intervention in regional organizations like the African Union or the Organization of American States. These regional principles may reflect shared traditions or institutional arrangements, but they are not automatically principles of universal international law. They remain regional general principles, binding only on the states of that particular community. And finally, the international level. This is where the statute of the International Court of Justice directs us. Only those principles which are so widely accepted across domestic legal systems and cultures that they can be called universal may be applied as general principles of international law. In other words, the international community accepts only those principles that are common to all or nearly all legal systems, principles that transcend legal families, religions, and regions. Examples here include pacta sunt servanda, res judicata, and the prohibition of retroactive criminal punishment. These rules are not regional or cultural artifacts. They are near universal pillars of legal reasoning. But international law also recognizes that there are some principles that are uniquely international in character, arising not from domestic practice, but from the nature of the international system itself. For example, the principle of sovereign equality of states, or the principle that no one can be judge in their own cause, nemo judex in causa sua, when it comes to international adjudication. These are not borrowed directly from domestic law, but are necessary to make the system of international law coherent. So, to summarize, at the domestic level, principles guide national law. At the regional level, they may reflect cultural or institutional consensus among a group of states. But at the international level, only those principles which are either truly universal across domestic systems or necessary to the very structure of international law itself qualify as general principles of law. These are the ones that international judges and scholars rely upon as the third great source of international law. Let us finally look at how they operate in international law itself. This is where theory meets practice. The Statute of the International Court of Justice, Article 38, gives general principles of law their formal status as one of the three primary sources of international law, alongside treaties and custom. The Court has repeatedly relied upon them when treaties and custom leave gaps, ensuring that the international system remains functional and coherent. For example, the ICJ and its predecessor, the Permanent Court of International Justice, have invoked principles such as good faith, equity, and the prohibition of abuse of rights. These principles act as safeguards against injustice and arbitrariness in the absence of written or customary rules. Recognition by the ICJ follows a careful methodology. Judges look across the world's major legal systems to see if a principle is shared, regardless of legal tradition, religion, or region. If it appears consistently across these domestic systems, it may be elevated to the international level. This comparative approach ensures legitimacy, universality, and fairness in selecting general principles. General principles of law are not all of one kind. Some of them are derived directly from domestic legal systems, transplanted into international law because they are recognized everywhere. Principles such as good faith, estoppel, or responsibility for wrongful acts belong to this category. On the other hand, there are general principles that are not borrowed from domestic systems but arise within the international legal order itself. Think of the sovereign equality of states, or the prohibition of the use of force. These are not simply domestic analogies, but foundational principles of the international community. This duality helps us understand both the richness and the complexity of general principles of law. There is an important debate about whether general principles of law must be truly universal. Some scholars argue that only principles found across all legal systems in the world can qualify as sources of international law. Others, however, believe that strong regional principles, for example, principles developed within European Union law or within Islamic or African legal traditions, may also influence the formation of international law if they reflect a consistent and deeply held consensus. This debate reveals the tension between universality and diversity, and it challenges us to think carefully about whose legal traditions shape the rules of our shared international community. General principles of law are not without criticism. Some argue that they are vague, that their identification lacks clear methodology, and that they allow judges too much freedom to pick and choose principles that fit the outcome they prefer. This creates a risk of selectivity or even manipulation. Others counter that without general principles, international law would be incomplete and fragile. Thus, the legitimacy of this source of law depends heavily on transparency and careful reasoning in how courts and scholars identify and apply them. There are also limits. General principles cannot be stretched to justify completely new obligations that states have never consented to. They are meant to fill gaps and provide coherence, not to replace the hard law of treaties or custom. Still, their flexibility makes them invaluable. For instance, the principle of res judicata, that a dispute once settled by a judgment cannot be reopened, is essential to international adjudication, even though no treaty explicitly requires it in all cases. Similarly, the principle of equity has been used to achieve fairness in maritime boundary cases. My friends, we have now travelled together through the three primary sources of international law: treaties, custom, and general principles of law. Thanks to your attentive listening, we have completed this essential stage of our journey, understanding the pillars that uphold the international legal system. In our next session, we will turn our attention to the other sources of international law, the secondary, supplementary materials that, while not primary, still guide and shape the behaviour of states and international actors. I sincerely thank you for accompanying me so far. Your curiosity and engagement have made this exploration meaningful. Keep following the journey, for there is still more to uncover about the fascinating world of international law. Until we meet again, stay curious, stay thoughtful, and continue exploring with the IntlLaw Academy.